That is People of the State of Michigan versus Yusuf Abdicator. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Johnson.
It's Luke Goodrich from the Public Defender's Office, here to represent Mr. Abdicator, who is standing to my right.
Thank you, Mr. Goodrich. And sir, you are Yusuf Abdicator, is that correct?
Sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think we have a preliminary exam date scheduled for next week. It's my understanding we're going to leave that set.
So that's is that a fair statement, Mr. Goodrich? We're going to leave on for prelim.
I'm not, we do want to leave it on for prelim, but I'm not sure there's actually a prelim date.
Is there not? Oh, okay. So we're going to need a
Because
date.
this has been adjourned a couple times because he didn't have an attorney.
All right, so it has been adjourned for good cause because he did not have an attorney. You are correct, sir. So at this time, A, is your client willing to waive his right to a preliminary examination within 21 days so we can adjourn it at some point?
That's already done and over with.
All right, so that's done?
Yeah.
I don't have, let's see, March.
Your Honor, I think at this point, we just need a prelim date. I think we're still within good cause at this point, considering Mr. Goodrich was just appointed.
All right. I have adjourned for good cause. D has prior FTA, October 10th.
That was at the original PCC, I believe.
All right, DFTA for PCC originally. All right. All right, so let's, so we don't have a good, so we don't have to worry about the 21-day rule.
Yeah.
And we'll just leave on for a new date.
My system shows a date of October 25th, but when I checked on the 54A website, I did not see that date, so I just wanted to.
Right.
If we set this for exam, but I can set it for October 25th at 9 o'clock.
That would work. I believe the co-defendants that date as well.
All right.
Oh, wait, yes.
So
yes,
so what's the co-defendant? So we'll put it
yes.
the
Dayton
same.
Akeley.
Dayton Akeley, and is that at 9 o'clock also?
No,
No, no, oh, no,
Is
he's
that-
in the afternoon.
I believe it's the afternoon. One moment,
Yeah.
please.
Let's
Because he has
place,
two files.
all right, let's place this
With the
file
other,
with that
yeah.
file. Yeah.
If that works with Mr. Goodrich's schedule.
That would be at 1:30 on October 9th.
Oc-
Or sorry, October 25th.
October 25th at 1:30.
Yes.
So we'll set it with the co-defendant October 25th at 1:30. Anything else for the record in docket 2402-546, Ms. Wilson?
Not for the people.
Mr. Goodrich.
No, Your Honor.
All right, we've set this preliminary examination for October 25th at 1:30, along with the co-defendants.
Your Honor, could you let me know how to spell the co-defendant's name? I gotta make sure that we don't have an issue.
And Dayton is Dayton.
I think Dwayne originally represented him and then he retained private counsel.
Oh, okay.
Yeah.
Okay, good.
And I do have that file number if you want it.
That's good. I
All
have
right.
the name.
He has a privately retained attorney, Mr. Goodrich.
Okay, so we're all set.
All right,
All right, thank you.
that's
Your
all
Honor.
for the record in that file. Thank you for your appearance today.
And then I think we're ready on Brooks.
And Eric Brooks. That's Mr. Johnson. All right, so.
Your Honor, you can confuse me with people with hair.
You'd be worse to be confused with Mr. Johnson, with Mr. Goodrich. All right, so we're on the record in docket 2401-529. That is a sentencing matter in regards to people of the state of Michigan versus Eric Brooks. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Johnson.
Good morning, may it please this honorable court. Kareem Johnson, number 71988, appearing on behalf of Mr. Brooks, who's standing to my immediate right.
And sir, you are Eric Brooks, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a sentencing in the matter. Ms. Wilson, is there any restitution in this matter?
Not to the people's knowledge.
All right. And Mr. Johnson, if you had the opportunity to go through the pre-sentence report with your clients.
Yes, Your Honor, and the substance abuse assessment.
All right. Any additions, deletions, or corrections?
Not to the body report.
All right, thank you. allocution, Mr. Johnson.
Well, Your Honor, as indicated in the report, this was a co-defendant case, and, typically, I'm on the other side of a case like this, where I have a client who's a dealer, who puts an individual who apparently is a user in a precarious legal situation. But for the conduct of the co-defendant, police would have never paid any attention to my client's home, wouldn't have searched my client's home, and wouldn't have found the small amount of drugs that were attributed to him. Now, he does have a drug issue that needs to be addressed, but he was not out here distributing narcotics to the community. He did not possess any firearms. He didn't pose a danger to the community. I think what was telling about the substance abuse assessment was his mental health history and the fact that he's under treatment of a psychiatrist, which further leads me to believe that he may have been taken advantage of a little bit in this situation. He knows he has a substance abuse problem that he has to address. He will comply with all terms of probation. I do not think that any further incarceration is necessary to punish my client. I think that with substance abuse treatment, continued mental health treatment, the court can trust that Mr. Brooks will not embarrass the court and commit new crimes while he's out on probation. I think the best interest of justice will be served with a probationary sentence, no further jail.
All right, thank you. Ms. Wilson, is there anything you'd like to say before the court addresses Mr. Brooks?
I think the recommendation is fair, Your Honor. I think following it would be appropriate in this matter.
All right, Mr. Brooks, is there anything you'd like to say to the court before the court passes sentence?
Yes, Your Honor. My mother passed away. I became depressed. Taking antidepressant medication. The guy on hand, the co-defendant, called me from. They were kicking him out of the hotel. I'm a pretty decent guy, so I went and picked him up, brought him to the house. I didn't have any knowledge about guns or nothing that was involved with the search. Again, I wasn't benefiting. The raid happened 10 days after I picked him up from the hotel. I don't feel that I was maintaining a drug house because basically I was in my room. I didn't really pay attention to what was going on outside of my bedroom, my depression. It's no stranger. I've been in trouble before in the past. When I got off parole, it was in my heart. I should never even be standing in front of a judge because I completely changed my life around as far as criminal activity. I would just ask that the judge go with the recommendation. I have a lot to lose. It's just me. I don't have any family since my mother passed away. I do feel that a term of probation is welcome on my behalf. Been seeing a therapist and a counselor dealing with my depression.
All right, Mr. Brooks, I'm going to, based on the recommendation, the judgment of sentence and some comments that you've made today, we're going to look at this. District court is not always a helpful court, but today I think it can be. All right. I'm going to follow the recommendations. I don't know what your relationship with the substance is, but we're going to turn this into a positive. I think that's what district court's for. So please take advantage of any of the opportunities that district court provides. Sometimes I know it's not going to feel like a positive, okay? But the understanding is that we want you to understand any addiction or substance abuse problem you might have and to work on those, all right? You're not a kid. I'm not going to treat you like a kid, all right? With this sentence is for a plea on August 2nd, 2024 to obtaining and maintaining a drug house and use of cocaine. It is the sense of the court that the defendant spent 180 days in jail beginning September 26, 2020. Credit is given for 2 days previously served. The remaining 178 days is suspended upon successful completion of probation. So that's kind of the stick, all right? No further jail time till the end of probation. I'm going to place you on probation for 9 months today. We're going to set fines and costs at $100 fine $100 cost. Crime victims' rights fee of $75, state minimum court cost fee of $50. Probation is set at $30 a month. For 9 months, it's $270. So I'll give you a grand total of that. 270 plus 50 plus 75 plus 200 is 595. That, of course, can be paid over the course of probation. Probation is set for 9 months at $30 a month. There's no contact with the victim, Mario Henton, or to be within 2,000 feet of where the victim lives, works, goes to schools without the consent of this court. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs or urinalysis as directed and pay those fees. No bars or nightclubs. That's just a good idea. I'm going to check the only thing that came out of that assessment, which it does not appear to be it appears to be an assessment that is done that it works well for you. All right, that indicates that you're low on the order of any criteria. Would be the cognitive behavioral therapy. I'll order that. So that'll be cognitive behavioral therapy. Complete following rehabilitative services, pay fees, and provide proof of completion. That is the only one I'm going to check in that regards. Okay, so that's good. Cognitive. Obtain and maintain employment or proof of disability should go to your probation officer. Not purchase or possess firearms, ammunition, or weapons of any kind. Provide to the officer, and you might have to provide a waiver. Provide proof of all prescriptions to probation officer so they know what you're on, mental health wise. Or otherwise, and then this report will be conviction will go to the Secretary of State for any license restoration. Okay, for any license. I'm not sure what it would be because this is maintaining and use, but that's always an option. So it's not but there's nothing here that would indicate that this is a driving offense that I can see. All right. Anything towards the sentence, Ms. Wilson?
Just briefly, Your Honor, you mentioned a no contact with a victim, Mario Henton. Mario Henton's the co-defendant.
Oh, co-defendant.
I don't have an issue with a continued no contact, especially considering Mr. Henton's case is not resolved, but I just wanted to make sure it was clear that Mr. Henton's not a victim.
It is. Mario Henton is the co-defendant. It says co-defendant right next to the name. Anything towards the judgment of sentence, Mr. Johnson?
No, Your Honor, thank you.
All right. No, I did not. We'll waive fines and costs on use on count. Well, let's do, that's the higher count. Okay. So we'll waive fines and costs on the attempted maintaining drug house. And then we'll assess the fines and costs, $100 fine, $100 cost, crime victims' rights fee of 75 and state minimum cost fee of 50. And then the probation on the use of cocaine, which I think is the 1 year offense on this. And then we'll waive it on the attempted maintaining a drug house. So just switch them. Yeah. Anything in that regard, Mr. Johnson?
No, Your Honor.
All right. So Mr. Brooks, how this works is the less we see each other, the better. All right. If you do your probation and keep your probation officer with up to date, there's no reason to violate you. And so you must have the better things to do on a Thursday morning with your time than to be here in front of me. The more we see each other, then we got a problem. Okay. Because then we're violating probation. And then I start digging into stuff to see how we can either help or use jail as a alternative. And jail really is the last alternative I want to use. All right.
Yes, Your Honor.
All right. That's all for the record in docket 2401529. Mr. Brooks, thank you for your appearance. I would check on the 5th floor with your probation officer just to make sure you know how you report and where you report.
Yes, Your Honor.
All right. Thank you, Mr. Johnson.
Thank you, Your Honor.
This was the.
And then I think we're ready on Dustin Herrick, whatever the code is.
All right. So that was Mr. Brooks. And who is the next case? That's Eric.
Dustin Herrick.
Do we have to bring up Mr. Herrick or is he?
We'll-
He
we'll
is
address that,
actually
Your
in
Honor.
Nuevo jail, so
Oh,
and we just
okay.
figured that out yesterday.
All right.
And we're sure he's not federally held, Mr. Goodrich.
I am sure, yes. I
Okay.
did confirm that with his mother.
Okay, perfect. I
All
know
right.
sometimes.
Well, yeah,
Because
Nuevo,
Nuevo's.
Nuevo's kind of famous for that, so.
Yeah.
All right, so we're on the record in docket 24-02669. That's people the state of Michigan versus Dustin Herrick. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Herrick, who is unable to attend because he is currently in the Nuevo County Jail.
All right, and it's my understanding, we just found that out.
Yes, Mr.
Okay.
Goodrich informed us late yesterday when he found out. Obviously, there wasn't enough time to get him on Zoom or otherwise. So I think at this point, we're gonna need a good cause adjournment.
Your Honor, I would ask that we perhaps treat the PE as a probable cause conference.
That works.
And then maybe we'll set a new PE date if we can get him here next week.
Do that fast?
Sure.
We're gonna
Give it
try.
our
We'll,
best.
we'll try to get him here next week. It'll make a writ to Nuevo County.
Even if it's just over Zoom, I think it would be.
Yeah, and over-
okay,
and
since if it's a
I would
PCC.
assume that they would not have any, because they're really a federal, I mean, half of it's a federal holding house. All right, so, okay, let's adjourn the PCC to the preliminary examination. So we'll adjourn the PCC to October 17th, 2024 at 8:30. And then we'll see if Polycom for that PCC is available.
If not, I'm asking for a writ. 50-50.
And then we'll do a writ in case.
And I do also want to alert the court that Nuevo is not the only county that has a hold for Mr. Herrick.
All right.
So I'll stay on this.
All right. You just let us know, Mr. Goodrich. But right now we've adjourned the PCC to the preliminary examination. So we've reset the PCC for October 17th at 8:30. And then we'll go from there. Anything else for the record in 24-02669? Ms. Wilson,
Not for the people.
Mr. Goodrich.
No, Your Honor, thank you.
Thank you. And
then
you've got a
I see-
couple people on Zoom.
Yeah, I see Mr. Shepherd and Mr. Barham are here, so I think we would be ready on that.
All right.
Yeah, we're ready, Your Honor.
That is Mr. Barron. And this is a PCC and my understanding is Mr. Shepherd's filed a motion. Is that
That's
correct?
correct.
All right. So we're on the record in docket 24-02611. That is people of the state of Michigan versus Philip Barham. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Shepherd.
Good morning, Your Honor. Eric Shepard here on behalf of Philip Barham. We're both appearing on separate Zoom feeds and we consent to the Zoom proceeding.
Thank you. And sir, you are Philip Barham, is that correct?
Your Honor, we can't hear you, Philip.
Okay. Is that correct, Mr. Barham? All right. I have the motion. I don't know if his auditory is working,
Yeah, I can see
but I
him.
did
Your
get the
Honor.
thumbs up that that's him. So,
Yeah,
Your Honor.
there you
all
go.
right, there you are. All right.
Yes, Your Honor.
And so you can hear me all right, Mr. Barham?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference, and then Mr. Shepherd has filed a motion for early return of subpoena. Ms. Wilson, how are we proceeding on the PCC, or is what we're doing on the motion dispositive today?
I think what we're doing on the motion is dispositive. It's my understanding, Mr. Shepherd is looking for some additional discovery that's not currently in the people's possession. So I think that we would need a new prelim date in order for him to be able to get that.
And my understanding is that the defendant has previously waived his 21-day rule on October 4th. Is that correct?
By stip and order, he did, yes.
All right, and that's true, Mr. Shepherd?
Yes, Your Honor.
All right, so the heart of your motion is the discovery request for subpoenas. So let's see if we can set it out. We'll set it out, and then we'll set it out for a continued PCC, I would think.
Okay, yep.
Yeah. So just to make sure we've got discovery before we do the prelim. Is that a fair statement, Mr. Shepherd?
Yes, Your Honor. I don't know if Ms. Wilson, obviously, I don't know if she opposes the motion at all. I mean, the whole point really of it is that I do all the work and that, you know, the court would sign the subpoena and make it a court order. And then I serve the subpoena upon Mr. Harris and upon Limelight Entertainment. And then I receive all the discovery and then I'm court ordered to give it over to Ms. Wilson. Once I get all that discovery, then obviously we can go through it and we can decide, you know, what's going to be coming in, what's not relevant, what is relevant. And we can try to hash out those issues, obviously, before we, you know, go into a preliminary examination. As the course indicated, that is going to take some time as far as production and then obviously review and preparation for the preliminary examination. So we would need a new date. My client's already waived 21-day rule. I'm not sure the time frame of what we're looking at exactly. I'm thinking probably about 30 days, but I'll leave that
All right.
obviously to the court's scheduling.
All right, and then Ms. Wilson, that based on the record that's been made by Mr. Shepherd, it appears that, do you have any objection to me signing the motion for early return of subpoena? Or did you want to look at that into it yourself? And it's entirely up to you.
So I have no objection to Mr. Shepherd seeking that.
Right.
I'm admittedly a little embarrassed to say that I'm not entirely sure what the early return means. And other people in my office didn't either. So I guess that's my only hang up. I don't necessarily want to agree to something when I don't know what we're agreeing to.
All right, so why don't we do this? Why don't we set the PCC date, and then I will look for a stip and order to for the motion for early return of subpoena concerning this. It appears it's just semantics that you know, because it appears that and the other thing is that I don't know, the people may want some time to stipulate to an order that they don't know whether they have the information or not. Usually the information comes to the people and then the people come
Right.
give it to Mr. Shepherd. But I know you're not looking for more work. So if Mr. Shepherd is saying he's going to get the information,
Right.
that's not a bad that's not a bad plan.
And if all we're doing is just a regular subpoena to get the documents, I have no
Right.
issue with that.
What you're anticipating, Mr. Shepherd, is that they won't do this without some type of order from the court.
We're not allowed to issue subpoenas in criminal cases, Your Honor. So the court
Right.
has to sign it as a court order. And because of that,
Right.
the early return just means that it's coming to my office before a court. Meaning that instead of the person showing up to court and then hand abundance, it comes to my office before, you know, the court proceeding. So I need a court
Right.
order to do that because I can't issue a subpoena in a criminal case.
That's fine.
Yeah, so
Yeah.
is that, it's just a little bit way of getting the discovery, and then you'd provide any type of request to the people. I'll sign that. I can sign that because that's coming to you, and then you're providing that to the prosecutor in relation to the case. Is that correct, Mr. Shepherd?
Yes, Your Honor. So I
All right.
prepared a proposed order and then I prepared the actual subpoena itself. And then, of course, there's the attachment to the subpoena, but that's just my preparation. So the court would just need to sign the order and then the subpoena itself at the bottom of page 1, I guess, on the subpoena.
All right, so I'm going to sign the order for early return of subpoena to defense counsel. You agree with that, Miss Wilson?
I do, Your Honor. Thank you.
And then I'm going to sign the bottom of the subpoena. So both those should be signed, and we will get a date about 30 days out. Do you want a PCC date?
I think that would be
Yeah, I
best.
do too.
Yeah.
So
That's fine.
PCC date about 30 days out will be
November 7th at 8:30.
November 7th at 8:30.
So you
That works for me, Your Honor. Thank you.
All right, thank you, Mr. Shepherd. And then Well, let's leave it for PCC, and since the 21-day rule has been waived, I'm not gonna set it for prelim yet.
That works.
And so, that'll mean that it's one less scheduling thing we have to do. So we'll set the PCC for November 7th at 8:30. I have assigned both the motion for the order for the subpoena and the order for early return of subpoena. Anything else for the record in 2402-611, Ms. Wilson?
Not for the people.
Mr. Shepherd.
Your Honor, is either court staff able to email me a copy of the signed documents, or otherwise I can pick them up? I don't know. If
Yeah, I think usually if it's a signed order, we send it to both parties.
Yeah, and then I believe it needs to be filed with 54A.
Right, so
yeah.
So we'll make sure it's filed. You may want to pick something up depending on your time frame, Mr. Shepherd, to make sure that you can serve it on the party, which is, I think that's
Richard Harrison, Limelight.
yeah, Limelight Entertainment and Photography. That
Yeah,
depends on your time frame, because if you're waiting, that may take some time if the court's doing it. That's all my fear is.
Yeah, I can pick up a copy once it's filed, Your Honor. That's fine.
All right.
Thank you.
All right, so we'll file the copy. We'll have it in the court file, each signed, and then we'll leave it to Mr. Shepherd to go from there. Anything else for the record in 2402-611, Mr. Shepherd?
No, Your Honor. Thank you.
All right, Mr. Barham, you're all set. Thank you for your appearance today, and we will see yourself and Mr. Shepherd here on November 7th at 8:30.
Thank you, Your Honor. Appreciate it. Have a good day.
Anyone in the jail?
No.
Ms. Wanji, you're here on DeAndre Ware.
I am, Your Honor.
All right. Did you need to meet with Mr. Ware? Are you ready to go on that?
We're ready to go.
All right. So let's go on there. All right, so we're on the record in 2402-477. That is People of the State of Michigan versus DeAndre Ware. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanji.
Good morning, Your Honor. Daniel Biwanji for Mr. Ware.
And sir, you are DeAndre Ware, is that correct?
Yes, sir.
And you can hear me all right, Mr. Ware?
Kind of. The volume is a little low, but I can hear you.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set for exam. I will note that this is a Mr. Pfeiffer vertical. However, it sounds like he's in trial next week, so I believe I will be covering.
All right. And that's a fair statement. Ms. Wanji will be leaving this on for preliminary examination.
We are, Your Honor. Thank you.
All right. So we have set this for prelim on October 17th at 8:30, and this will be left on. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in 2402-477, Ms. Wilson?
Top of the people.
Ms. Wanji.
Nothing for the defense, Your Honor.
All right, Mr. Ware, you're all set. We'll see you here live and in person on October 17th at 8:30, okay?
All right, thank you.
You're all set.
Thank you, Your Honor.
Thank you, Ms. Wanji.
I also have LC, Mr. Wilson. I believe that he's on Zoom.
Let's see. Oh, is that LC? That might be LC.
Yes.
Yeah. Did he make it on Zoom?
Yes.
Okay.
Yeah.
Because I know we got an email saying he was having difficulties.
All right, and you're ready to go on that case, Ms. Wanji?
I am, Your Honor, and we're going to leave
All right. All right, Mr. Wilson, you can unmute yourself. Mr. Wilson, you can unmute.
You hear me now?
All right, I can, thank you. So we're on the record in docket 24022976. That is people of the state of Michigan versus LC Wilson. Will the parties please introduce themselves for the record? Miss Wilson,
Abigail Wilson for the people.
threw me a little bit. Miss Wanji.
Good morning, Your Honor. Melanie Albiwanji for Mr. Wilson.
And sir, you are LC Wilson, is that correct?
Yes, sir.
And you can hear me all right, Mr. Wilson?
Yes, sir. I can hear you fine, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're gonna leave this step for exam.
Is that a fair statement, Ms. Wanji?
It is, Your Honor.
All right. So we'll leave on for the previously scheduled preliminary examination for October 17th at 8:30. So Mr. Wilson, we'll leave on for prelim on October 17th at 8:30. That'll be live on the 6th floor of City Hall of Lansing next week at 8:30, the 17th being a Thursday at 8:30. Anything else for the record in docket 24022976, Ms. Wilson?
Not for the people.
Ms. Wanchi?
Nothing for the defense, Your Honor. Thank you.
All right, Mr. Wilson, you're all set. Thank you for your appearance today.
Okay, you're welcome. You have a blessed day.
You too.
Thank you.
And then I think we're ready on Perdia. Cancel.
All right, that's Ms. Robinson.
Yes, she's right here.
Oh, Ms. Robinson, I thought I saw you on the Zoom.
I was
All right.
previously. I feel like I'm always invisible in this courtroom. no matter where I sit.
Peridia. There we go. All right. All right, so we're on the record in docket 24022705. That is people of the state of Michigan versus Mansell Peridia. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Pareda.
And sir, you are Mansell Peridia. Peridia, is that correct? You have to unmute.
Yes, Your Honor.
All right, you can hear me all right, Mr. Peridia?
Yes, Your Honor.
This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're gonna leave this set for exam next week. I should have an offer over to Ms. Robinson early next week.
And that's a fair statement of Ms. Robinson.
It is, Your Honor.
All right, we'll leave on for preliminary examination for October 17th at 8:30. So, Mr. Peridia, that's live in person on October 17th at 8:30. That'll be next Thursday at 8:30. Anything else for the record on 24022705, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, we'll see you next Thursday at 8:30 in person. Mr. Peridia, you're all set. Thank you for your appearance today.
Will that be the 5th floor on Michigan?
It'll be the 6th floor of City Hall of Lansing.
Okay.
So
thank
the address here is 124 West Michigan, right across from the Capitol on the 6th floor.
All right, thank you, Your Honor.
Thank you. You're all set.
Have a good day.
You too.
And then I think we're ready on Tyrese Jones.
All right, Mr. Jones
I have notes on that.
is a motion for bind over, and it was briefed. I've got the briefs, and I read through the briefs and both preliminary examinations. That was the preliminary examination. Initial one was, and that was part of this. We bifurcated this
Yes.
prelim. So let's go ahead and call. So we're on the record in 24013868. That's people of the state of Michigan versus Tyrese Jones. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Jones.
All right, as previously indicated, I was making a record of this and I decided we should really just put this on the record. This was a preliminary examination that was completed, but it was bifurcated in nature. So I wanted to make sure that we had both prelims and that I'd read through both prelims before I made any decisions on the motion for bind over. So it's my understanding the motion for prelims the motion for bind over is going to address the testimony of Donovan Moore, the testimony of Jamil Jones. And then the bifurcated session, that was Thursday, June 27th. And then we had a session 2, Friday, August 2nd. And that was the testimony of Tyler Stowe. And at that, the second session was at the request of the defense attorney after the first 2 witnesses testified. That's my understanding.
That's
Is
correct.
that fair? Is that a fair statement, Ms. Robinson?
Yes, Your Honor.
All right. All right. And then I have had the opportunity to read the defendant's motion to deny bind over. And Ms. Wilson, you may proceed.
Thank you, Your Honor. After reviewing the transcripts in this matter and seeing how the testimony actually came out, it was not the way that I recalled it coming out. At this time, the people are unable to proceed.
All right, Ms. Robinson, so you're gonna, any comment on that?
No.
Okay, I didn't think you have an objection to the, so I'm going to grant, so you're not making a motion, is that?
I'll make a motion to dismiss. Judge, to
Okay,
make it
all
easier.
right.
That's fine. Yep.
All right, so the people. I'm indicating that people do not make a motion for bind over. And defendant moves to dismiss. This without prejudice. So I will entertain a dismissal without prejudice of the case. Everything's a little slow today and yesterday. So
For whatever reason, this specific courtroom seems to have the worst internet connection.
And it's so iffy.
well, you should have seen us with the civil, with our
Oh.
civil and our, it was kind of a mess yesterday. But it worked out. All right, so Mr. Jones, I'm in possession, I can hear that. I'm in possession of a motion to dismiss without prejudice based on the testimony of the 3 officers and the refusal for bind over. There's a motion to dismiss without prejudice. Based on the 2 counts, dismissal without prejudice means the people could reissue if they choose to, but realistically, for our case, for our purposes today, the case is dismissed. All right, sir? All right. I will sign it accordingly. And the case is dismissed as of today. Anything else for the record in docket 2401-368, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, you're all set, Mr. Jones. Thank you for your appearance today.
Oh, I gotta grab it. It's rather large.
Mr. Jones.
Yeah.
I just- I
And
forgot about one of the courtrooms.
I think we're ready on Frazier. He is in custody and I guess the jail for some reason is not putting him on poly.
They actually just left the Zoom meeting.
Yeah, so.
All right, so Mr. Feigelson, you'll let Mr. Frazier know whatever we're doing here today.
Judge, I did
It's just a
see
piece.
yesterday, and I can
All
put
right.
what's going on the record.
All right.
It's easiest. Judge, I do have a packet for you, but I can just approach when we're moving on the record.
Yeah, okay, that'll work. All right, so we're on the record in 2402-956. That is people of the state of Michigan versus Devin Frazier. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson. for the people.
Mr. Feig.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Flagelston on behalf of Mr. Frazier this morning, Your Honor.
And we are waiving Mr. Frazier's appearance today, Ms. Wilson. My understanding is he's supposed to be on Polycom. We're having some inconsistencies with whether he's going to be placed on Polycom. And then so it's my understanding that whatever we do here at PC, Mr. Feigelson, you're going to let Mr. Frazier know how we're proceeding. Is that correct?
That's correct, Your Honor.
All right. So I will leave it to Mrs. Wilson, or if you want to defer concerning this matter.
Thank you, Your Honor. It's my understanding, Mr. Feigelson is planning on referring Mr. Frazier to competency.
Your Honor, that is accurate. Let me give you a little bit of background. He has two other pending matters in front of Judge Ward. Both of those are being referred for competency. I believe he is meeting with the Forensic Center on Friday. I did meet with him last night, or not last night, but yesterday, late in the afternoon. He was aware of the intentions in regards to this case, as well as what's happening in the other cases, Your Honor. I have the packet available. I'll approach when I'm finished. As for what we want to do, I do believe that adjourning the prelim out to allow the competency evaluation to be done would be appropriate. But I would like to have him present to make that. I think we could find good cause, but I don't have an issue with doing that next week, because I believe they can bring him here for purposes of the exam and just waive the timeline to 21 days at that point.
All right.
Or if the report's back in time, address it at that time too.
Well, let's do that. We'll leave on for prelim for next week, so we'll have him here,
Right.
and then we can address this as in regards to. Do you have the packet?
I do,
with you?
Your Honor, for
Yeah,
the approach.
and I can. And that if this is unusual, because usually we don't have the report or the interview set up. It appears this interview is already set up because there are two other files in front of Judge Ward.
Correct.
And then this one's just going to kind of piggyback on top of that file. Is that your understanding, Ms. Wilson?
That's my understanding. As to the waiver, though, I believe filing the packet kind of tolls that timeline, and I have a little bit of some reservations about having Mr. Frazier waive a right when there's a question of competency. So I don't know that.
That's fair.
Yeah,
That's
I don't
fair.
know that we should have that waiver next week.
You make a good point. I think we could find good cause, Your Honor,
Yeah.
given the.
Yeah. Well, I think as soon as I sign this, it kind of waives it.
Yeah.
Right.
Or for our purposes. I believe Ms. Wilson's correct. And really, we're just piggybacking on the other two files. So we have that date set up for the review or for the interview for Center of Forensic Psychiatry. I'm going to sign the order, and that will toll it or waive or will toll the waiver period for the other two files. And then Mr. Feigelson, you can let Mr. Frazier know the extent of that he's going to be interviewed, and that's going to toll the statutory period.
I didn't make him aware of that yesterday. I'll meet with him early next week and make sure.
All
he's
right,
aware of it.
perfect. All right, so I'm going to sign the order for examination. Which Ms. Wilson is correct. That'll toll the preliminary examination date, and then we'll get the report and we'll go from there.
Correct, Your Honor.
All right. All right. I will sign it as of today's date.
Judge, if I happen to get the report, because I know that it may not make this file, I'll make sure your office gets it.
Thank you, Mr. Feigelson. That'll kind of see where we head next. All right, I've signed the order for competency examination. I'm going to place it in the file. Anything else for the record in 24-02-956, Ms. Wilson?
Not for the people.
Mr. Feigelson.
Nothing of after Mr. Fraser, Your Honor. Thank you.
Thank you. You're all set. Thank you for your appearance today.
Thank you.
Sure.
Mr.
Just just let me know and we can address that if he has a change or a movement where he's staying. We can work with that. And
This may go to Judge Ward for case.
all right,
consideration purposes,
yeah.
Is what Shelley and I are trying to work
All right.
on.
I'm good
to be
with that.
perfectly
Perfect.
honest with you.
all right,
That's what we figured was
It
gonna
got split
happen.
because board doesn't have exam time. So in that magical cycle, how things work around here that
Yeah.
nobody gets.
I get it.
Okay, so it may go. She's
Okay.
gonna check with her judge.
all right. That sounds good. Thank you, Mr. Feigl.
Thank you, Judge.
All right, so we're on the record in docket 24-02805. That is People of the State of Michigan versus Joseph P.R. Oakwood. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Joseph Oakwood.
And sir, you are Joseph Oakwood, is that correct?
I am.
Thank you. This is the time set for a PA 53 violation. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. In speaking with Mr. Lee, I think we've come to a resolution in this matter. The offer that the people have relayed is for Mr. Oakwood to plead to the sole charge of the complaint, the domestic violence. There would be a Killebrew agreement to no further upfront jail and no objection to 7694A status should Mr. Oakwood be eligible. In exchange for a plea today, the people would be requesting the court dismiss the PA 53 violation.
Jail, so that'll be a Killebrew of no upfront jail, no objection to YT. Is it YT?
7694A.
No objection to 769-4A status. And this is a plea to the 93-day misdemeanor.
That's correct.
And as a part of this, that's in the recommendation is to not proceed on the PA 53.
That's correct, Your Honor.
Is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
All right. Mr. Lee, may I inquire of your client of his misdemeanor advice of rights?
Yes, Your Honor.
Thank you. Mr. Oakwood, you understand you have the following jury trial rights in this misdemeanor plea. You'll be pleading to a misdemeanor punishable by 93 days and or $500 in the Ingham County Jail or costs. There is an agreement between the lawyers that there's a Killebrew of no upfront jail. There's also an agreement that the people will not object to 769-4A status if it's available to you. If I don't follow either the Killebrew agreement or the objection agreement, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Understood.
All right. So you have the following misdemeanor rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney John Lee, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court or any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, or to testify at trial if you choose to testify. Do you understand your jury trial rights, sir?
I understand.
If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your wish today to waive your jury trial rights and plead guilty to the domestic violence charge?
Yes, it is.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm going to bring your attention back to September 18th of 2024 at the offense location of 920 North Pine Street in the city of Lansing. Were you at that address, 920 North Pine Street in the city of Lansing, on September 18th, 2024?
Yes.
And who is Jane Bogenauer to you?
She's the mother of my children.
Okay, so you have a child in common, right?
Yeah, two.
Okay, so you have two children in common. You understand today you are admitting to the court that you offensively touched Ms. Bogenauer in some way, and that you did not do so in self-defense. So what did you do in regards to Ms. Bogenauer that makes you guilty of domestic violence? And Mr. Lee, feel free to ask any questions if you choose.
Did you shove her to the ground? This happened.
Okay, and you did not do so in self-defense, is that correct? You got to say yes or no.
If you say you did it in self-defense, you're offering a complete defense to the charge and your plea will be rejected. If you say you did not operate in self-defense, you're pleading guilty to the charge.
No.
Okay, so you did not do so in self-defense, and this was not done by accident. You did this intentionally.
Yes.
All right, Ms. Wilson, any questions concerning the factual basis?
Mr. Oakwood, you understand that by entering this plea today, you're giving up the right to claim that this wasn't self-defense?
Yes.
Okay, I think that's sufficient, Your Honor.
All right, any questions on the factual basis, Mr. Lee?
Nothing further, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made, and we will refer to probation. And what they're going to do is they're going to do a report for me, and then we'll see what options are available to us. All right. So refer to probation. We'll set sentencing date for
December 16th at 1:30.
sentencing is set as December 16th at 1:30. So go down to the 5th floor. That's where probation is, and they'll either see you now or they'll set up an appointment, and then they'll do a report. Be as candid as you can for that report, and we'll see what options are available at December 16th. All right, sir?
Okay.
Anything else for the record in 2402-805, Ms. Wilson?
Briefly, Your Honor, I just want to make sure we're clear because there was an allegation in the PA 53 that's being dismissed of a possession of a firearm. And I just want to make sure that we're clear that even if we lawfully own a firearm, that firearm needs to be surrendered either to the police or in the possession legally of another person that's allowed to possess a firearm in accordance with the terms of Mr. Oakwood's bond. And I will also state that during his term of probation, there will likely be, well, actually, even if there is an order that isn't an order that he's not to possess a firearm, there are new DV laws that state that he could be charged with an additional felony for possession of a firearm during that time, even if he lawfully owns it. So I just want to make sure we're clear that there needs to be a surrendering of any firearms if there are any in anyone's possession.
All right, Mr. Lee, you've made your client aware of that?
Yes, he's aware.
All right. Most likely as a part of the probation, there's going to be a no possession of firearms is associated with it. So in that indication as a part of probation, that'll most likely be one of the orders of the court. So you should make sure that if it's not in police custody, any firearm is with a person who has legal right to or legal access to it, okay? To the firearm.
Is that like authority or family?
You are not allowed to be in possession of a firearm.
Right.
So you have to give it to somebody else.
Yeah,
Gotcha.
give it to somebody else who.
Yeah, that's not a problem.
Who's not a felon.
Who's not a felon, who doesn't run into any, who's not a felon or incarcerated or minor, you know.
Okay, that makes me feel.
All right. And as a part of this, I'm dismissing the PA 53. Is that correct?
That's correct, Your Honor. Thank you.
It's the date of the 28th, so something we show up to.
I'm going back for sentencing on December 16th. Double about to address that. Your Honor, I do have one other thing I want to
All
ask
right.
about. There is a no contact order in this file. In fact, that was the nature of the PA 53 here. Mr. Oakwood feels under siege. He's getting called, he's getting emailed, he's getting texted. The complaining witness is showing up at his address. They have 2 small children. She relays to him that she's desperately in need of his help and assistance. And as a father, he feels compelled to respond. So we would like to adjust or amend the no contact order somehow. Either establish a third party contact, go between the 2 of them or something so that she is not contacting him directly and putting him in a position where any response for him is a violation.
Right. First of all, if you're contacted by the victim, your first response should be to call LPD. All right.
Okay.
Yeah, that places you at risk because you're in violation of no contact order, and that so she will be told to remove herself from if she's coming to your house or anything like that.
Okay.
That's just for your own protection. I have no objection to. They have 2 children in common.
They do, Your Honor, and she's actually in the hallway. I can go and ask her
You
her
can,
opinion.
right.
Okay.
Have her come in here and let's put it on the
Okay.
record.
She does have a small child with her that, it's on my understanding, is on the spectrum, so she might be a little noisy. Just to
All
be
right.
prepared.
All right. All right, so Ms. Bogenauer, I'm going to indicate there's a no contact order in regards to Mr. Oakwood. But it appears that there's some question as to, so you should have no contact with Mr. Oakwood. Do you understand that, ma'am?
No, because CPS told me that the no contact order only applied to me and not him.
All right, it applies, I'm telling you what I'm ordering,
Okay,
okay?
okay.
So don't, this
So
doesn't
this is
apply to
you
the
today?
CPS. This is what I'm ordering.
Oh, okay.
And the criminal file is a different file than whatever Child Protective Services file is, okay? So Mr. Oakwood, that's okay. Mr. Oakwood, it's just have no contact with you. So you can't go, what's gonna happen is if you go and contact him, he's gonna call LPD.
Okay.
And the Lansing Police Department's gonna come and they're gonna remove you. But if he goes and contacts you, that's different, right? So that's the first thing. The second thing, it does appear that there's two children in common and there should be contact.
And we're on a lease together until February, and I don't drive. I'm on disability, and we have two
Right,
special needs.
so
kids.
you should contact, so there are lease provisions for a domestic violence case concerning this matter, all right? But what I'm gonna do is I'm gonna allow contact with the children through an adult supervision, so Adult Supervision Act that doesn't include you, because you're part of the no contact.
Okay.
Who would be a good person for that? Do you have anybody that would be a third person contact?
My mom just died. My best friend just moved.
right.
I don't know.
All right,
So
do you, Mr. Oakwood, do you have any third person? Because I can't order a contact if there's no third person. An adult supervision.
It's possible I could maybe get an aunt or uncle.
All right, if that would have to be okayed by the Ms. Bogenauer. And so we kind of just leave that to Protective Services,
Yeah.
to the Protective Service file. So I'm gonna leave that to them to consider. That's what Child Protective Services is for, to make sure that the children are safe. But so at this time, I'm going to reiterate, there's a no contact order between the two parties. And that includes, and so even, I understand how stressful this is, but if you contact Mr. Oakwood, he can't talk to you.
I understand.
Okay, all right. And then we'll readdress this at the sentencing if we have to. And you'll be contacted by probation to give any indication about what you feel on the case by
Okay.
probation.
And do we know when sentencing is?
Yeah, it's December 16th.
Okay.
All right. And you should be contacted by probation sometime before then, all right?
Okay.
All right. So, all right, so you're all set, Ms. Bogenauer.
Okay.
Thank you for your appearance today.
Thank you.
All right, and you can leave. All right.
Give you a call later, Jan.
Okay.
All right, and then Mr. Oakwood, you're set for December 16th. I'd go down to the 5th floor. Make sure you know who to go to. Make sure you know who to go to in regards to probation, and they'll do a report for me on December 16th. Anything else for the record in 2402-805? Ms. Wilson, also, I've dismissed the PA 53 violation that was initially scheduled for today. Anything else, Ms. Wilson?
If Mr. Oakwood doesn't mind just waiting a bit to give Ms. Bogenauer an opportunity to get downstairs, we don't have any further
All right.
issues.
So, Mr. Lee, that shouldn't be a problem, should it?
That is no problem at all.
All right,
I can also escort him down.
That's
all
right,
right,
yeah.
all right. And so, Ms. Slaviak will send you down, will escort you to probation so you can set up and know who to contact in that regard. That's all for the record in 2402-805. I will see everybody back here on December 16th. Thank you for your appearance.
Thank you, Your Honor. And we're moving the final pretrial on the docket as well. I'm assuming.
Yes.
Yeah.
So you can, I don't think you have to tell Wendy twice. The room.
No, I'm sure.
That is people of the state of Michigan versus Asanga Marembia. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Lee,
Assistant Public Defender John Lee on behalf of Isanga Allen Marimbaya.
and sir, you are Isanga Marembia, is that correct?
Marambia.
Marembia, thank you. All right, this is the time set for a probation violation hearing. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to the violations.
Oh, and I am probably screwed.